All right, Jazz Cabbage Cafe special edition.
Yeah, buddy.
Yeah, Stacy, of course. Uh,
Hello, everyone.
kind of hosting more than even co-hosting, but there's a lot of activity going on in the labor pool for the emerging cannabis industry, and there's some questions that need to be answered. There's a range of them. I think a lot of people look at some of the promotions and some of the discussions that we've had in the past and think this is purely, just pro unionization. In some ways it is, because there's the need to have that kind of gap filled, where some of the conditions are kind of the standards are realized by some places. There are some places that covet their workforce and create really good conditions. So in part it's about evaluating your situation and seeing if it's a good fit. And then the union itself has to be a good union. So there are ways that you can determine that. And this isn't just about just doing something for the sake of it, So that's kind of the point. There could be some benefits if everything lines up correctly and make some sense and help to shape this emerging industry and not let it necessarily fall prey to some of these really sterile corporate approaches that come out of seasoned industries.
Very well put.
So,
Very well put. We're seeing a lot of downfall right now because of a lack of I guess understanding or want to incorporate the legacy growers and the legacy patrons into the license market, and this is the result. So yeah, there's a lot of closures and a lot of like acquisitions and things like that happening, but that isn't the complete issue here. The issue is that you know the existing companies that we have are not providing what they're promising. And that comes down to everything from health and safety to forward movement in the industry. And it's important to know what to look for. When it comes to a grow, for instance, or even a lab or processor, when the CRA decides to release bulletins on certain things, employees should know about that, because at the end of the day, if the employee isn't informed, they're likely doing something wrong because somebody else was doing something wrong in the first place. It's just a very big lack of communication that comes down to our products, as consumers, not getting the quality that we deserve, and not being the right work environments, for the citizens of the state. So that's kind of where we're at right now.
hey, okay, so Tony Paris, and I'm reading this from the Sugar Law Center, is joining us, and I'm really happy to have you on here. And I know you've been probably paying attention to a degree, and also having conversations with Stacy and others, and have an idea, of what's going on specifically in cannabis. But your expertise is surrounding labor law and that type of thing, and so it's perfect, because a lot of people now are in a situation where there's some stuff going on and they need some help and some questions answered. And thanks a lot for coming on and being a part of the special edition broadcast to help people out.
Thanks for having me. I mean, it really is a perfect and ripe, topic in industry, and it's kind of good to be able to apply age-long, decades-old, almost century-old labor laws to a new industry.
Yeah, so sometimes there are applications that directly help out this emerging industry. And I was just talking about how sometimes there's kind of sterile corporate approaches that were born out of more seasoned industries that sometimes get misapplied here. But there are certainly times to look out for when you're trying to benefit the labor force anyway. That this could be very helpful. That's a good point.
Exactly. Yeah, and I know, Jamie, we definitely wanted to talk about, when some of these places close down, like we're seeing right now, or if you're let go, from a dispensary or any kind of, sector of the cannabis industry, because we do see such high turnover. How do you relate that experience onto a resume without, making it be questionable to your employer? And also, what can you do about insurance if you're let go or find yourself not being able to, work your current position? What can you do besides Cobra? We know that if you're getting paid $12 to $14 an hour, you certainly aren't going to be able to afford Cobra. So what are some other alternatives there too?
So I'm not an expert on that necessarily, but I did find myself in this position, and I was able to get a hold of a healthcare insurance agent who used the the government network to determine that I was eligible for some assistance, and I got a situation where I was able to keep my doctor, my medication coming. I'm getting older and falling apart, so these things are a lot more important. And it didn't cost that much. And the Cobra alternative was a lot more.
Right.
And so I did have an agent lined up to come on and help explain that a little bit, because I'm not the expert in it. But I mean, you can just certainly know that there's other options out there, and somebody who is an agent who you may trust or get a referral to. And hopefully maybe he will still join us. His name is Darius. He was great. Be happy to make referrals to people, if they need it. But there are other programs in place. And when you lose your job, your income goes with it at the moment. And that makes you more eligible for some of these, programs. And the point is to try to get people an avenue to healthcare. And for as much, criticism, I guess, of some of those programs have gotten, I'm certainly pretty happy for it right now. I want to read what Chris Silva said here. Great episode topic, fam. Employees are being taken advantage of extra hard by these chads because they know these kids have a dream and passion for cannabis. Thank you for speaking about it, everyone on the show. And thank you, Chris. And we said earlier, like there could be a real need for, there's overestimations, there's different, variables that occur due to how the rollout for the industry has taken place. And there are times when there's no activity and there is scaling back, and there is like the bottom line need to not have, a building full of employees at certain times. But being aware of these things, sometimes having the union in place, sometimes people demanding certain standards, conditions to work in, could ease those changes a little bit. Some people get committed and then they get caught up and, left in a lurch, and their families, and just all of a sudden, unceremoniously, unexpectedly, you're out.
Yeah, very, very well put. Very well put. And, when you find yourself jobless, whether it be by choice because, promises weren't fulfilled, or because, there's a lot of erroneous firing that happens in cannabis, for a lot of different things. As we know, it's a right to work state. So you like the color purple and, your boss doesn't, and, there you are. But it's important to know how to, because at the end of the day, you could be somewhere for a month, you could be somewhere for 6 months, you're going to gain some kind of experience. And, Jamie, when you and I spoke, you brought up a great topic of how do you navigate that on your resume?
Yeah. So, when I've had to evaluate some of these and conduct interviews and things like that, one thing that there are certain conditions people don't like to see, a leap from job to job quite often, because that could mean certain things. But when you're in a situation as we are, there's more understanding of why somebody may do that, and that can be explained, and that can be pointed out by way of better conditions at this next place. Or in other words, there can be the positive move that could be discussed, as opposed to issues or negativity with the people at the last place. And it becomes a little turnoff when you say, well, I left this place because the manager was a dick, and I left this place because they didn't treat me well, or whatever. Sometimes there's some truth, in some of this, but the presentation, negative versus positive, is a big deal. It can overcome some of that, looking like you're just jumping around for whatever reason.
Right, absolutely. And with the turnover rate being around 50 to 55% in cannabis right now, 50 to 55% of cannabis workers don't last more than 90 days. That's crazy.
Well, you're applying some of these, approaches of just being okay with like steady turnover, as part of your strategy, and not the more, fair maybe approach of kind of hold on to a good workforce and pay them appropriately and bring them in on the rewards when everybody comes together and works hard and creates a successful outcome, and and foster that environment where people are motivated to want to do that. And that kind of stuff. So we do start having some questions coming in. I think that for the lawyer, and I know also, I know, Stacy, we wanted to get to like some of these preliminary things about the resume and healthcare, and I wanted to have some help with that with some other guests. So if they come on, maybe we'll get into that a little bit more. But you're filled here with a lot of work and information and focus that you've been involved with. We have the attorney here. Some questions are starting to roll in. So I think let's go for getting the information out, the issues that have been caused, by these things, with the questions that people have, what people can do, that type of stuff. And as much as that as you want to facilitate, we'll bring up some of the things that people are asking here. Can a non-disclosure agreement or a non-disparagement post-separation agreement be broken if the information proves criminality?
Ooh, interesting.
So I can start with that one. Not every NDA or confidentiality agreement really is the same. Usually there's something in there that provides for, if required to testify or otherwise participate in any investigation by a government tribunal or anything like that, then it's waived. So usually when you're signing those types of things, I always was trained to make sure that the language is mutual. A lot of times when they're dealing with a separation, potentially a severance agreement or some type of, sometimes we won't dispute unemployment, or we'll give you a few weeks or whatever it is. I was taught that you just want to make sure it's mutual, that if you have to non-disparage them, it has to be all parties. And half the time when I, revise these agreements or send changes to them, I'm just changing employee or former employee to both parties. So it's kind of a mutual street, not only for potential later job references or other types of, we were talking a little bit about, potential blacklisting or other types of things that might arise that I'll probably get to later. But really, you want to make sure that you remember that you're always allowed to say truthful information. It's not defamatory if it's truthful. If it's a complete confidentiality over every term and condition of the settlement and everything that is tied to your employment, that's one thing. And you probably are only allowed to get around that if you're asked to testify into some type of formal proceeding. But otherwise, when it's just proprietary information, trade secrets, client lists, customer lists, that's fairly standard. And then when you deal specifically with disparagement or defamation is a standard that's fairly high. You have to be saying something that to be truthful or know to be untruthful or with high likelihood or reckless disregard for the truth for it to be defamatory. So that's going to protect you to go off and say, certain things or opinions that might be truthful. Or otherwise are just opinions, like I don't feel like that place is X, Y, and Z. And then remember that usually the first draft is usually not mutual. It's usually them trying to say, hey, we're giving you this amount of money so you don't say anything negative at all. Or so you don't ever acknowledge, what you received to sign this. Everyone's different, but you can just probably say, I just want this to be both ways. A lot of times I write in that there will be a positive job reference or a neutral job reference at most. Michigan doesn't have a specific blacklisting law like many states do. Even the great state of Texas has a anti-blacklisting law, but Michigan doesn't. The issue is whether or not blacklisting in general as a term is kind of applied to whether or not you're defamed or whether or not they're allowed to otherwise kind of engage in activity amongst different, I guess, owners or operators or employers that would prevent you from getting a job elsewhere. That's a lot of potential defamation from their point of view or disparagement from their end. And if they're going around doing that, they can get in the same level of trouble as, if you would have broken it pursuant to whatever, you had signed, as long as it's mutual. There's a good firm out there too that we use sometimes, Allison and Taylor. Allison's with one L, that actually does a whole fake, well, it's not even really fake, I guess, necessarily, but a whole job reference check for you and see what they say, when they say it, how they say it, whether they're being reckless with any facts. Any attorney in the corporate side worth, a dime is telling employers only give the dates of work, the job position held, and their rate of pay sometimes. Don't give any other additional information that could be construed as negative, defamatory, or otherwise get us in trouble for a potential lawsuit about that. That's how every larger corporation usually handles it. Even if you did something that could be, a red flag, they're really not supposed to do any of that. The problem with that is when they get a neutral job reference, or even let's just say, yes, she only worked here, and that's it. Sometimes that tells a prospective employer there might be something up because they're not saying anything. So you can sometimes write into those agreements, those NDAs or whatever it is, that a favorable or neutral job reference will be provided, and here's the contact to give people in human resources or whatever it is in order to provide that information.
So what if, you start working somewhere and the contract doesn't have any of those things, like, a neutral reference point or anything like that? What can employees do when they've been let go and they're looking at this piece of paper saying, I don't really know if this is good or this is bad, but they're telling me they're going to give me $3,000 and I don't have a job now. What do I do?
So just like you said, because we are in an at-will world, almost never are there those types of agreements or policies on the front end when you're hired. It comes up later when there's a layoff or some firing that could be construed as weird, or the lawyers that are against me do it to limit their risk, right, of potential cases, to kind of keep it all easily for their insurance or their adjusters or whatever it is, to say this person's not a risk any longer for any type of case, even if we are at will, because they've signed this agreement. So it comes later on during the separation, if it comes at all. And when it does happen that way, you really just want to go over it. I mean, they have to provide certain time for folks to review it or otherwise consult with an attorney. If they sign it, they are usually allowed to withdraw their signature within a certain amount of time. If they haven't, if they no longer want to do that. But that's where you'll see all that language, and every one is different, and every severance can affect unemployment in different ways. Every severance can affect, has broader or narrower language based on confidentiality or non-disparagement. The standards are that you're waiving most, if not all, potential future lawsuits, that you are not going to disclose the terms of the settlement, and that you're not going to shit talk or otherwise, defame or disparage the other side. Defame, we don't really got to worry about. There's separate legal provisions for that. You're not supposed to be defaming people anyway. Disparagement is more of the legal term of art to worry about, because disparagement being just negative in general, but often truthful, is where that word always raises a larger red flag to me. Because disparagement is like me just being honest about how bad it was, right? Defamation is me not telling the truth about how bad it was, or being very loose with the truth about how bad it was. So when employer side people are saying you can't defame us, it's almost like, yeah, that's an obvious thing. You shouldn't have to sign any of that. In the rare cases that any employer out there does have a severance policy, or does have, if you're separated due to no fault of your own, we provide this level of severance, we provide this type of vacation pay, or your PTO upon separation paid out, then for the only time really legally the handbook or the contract or the policy that you signed when you first began becomes binding. Normally, those things aren't as good as, they're not worth the paper they're written on. They're not contracts. They're not, they're one-sided guidelines that are meant to have be pro-employer. They're made really to try to deny your unemployment insurance most of the time, to say that you broke some rule that you should have known about when you signed it back when you began. And any attorney that doesn't want to get malpractice on their side writes in there, you're an at-will employee. It can be broken at any time for any reason. This is not to be construed as a binding legal document. Where you see those policies or handbooks or, you know, things that you get when you first are hired on finally get legal weight is if it requires you to have a PTO payout at the end of everything. Michigan law requires it, then they have to follow policy. Sometimes if it's a severance policy, even if they think they can change it at will, if they're not doing it uniformly, if they're paying it out only to certain people, and you're looking for here differences in race, age, religion, national origin, gender, disability, all of those protected classes under federal and state law are really the only times that you can't play favorites. You had mentioned, like, you know, purple didn't like the color, didn't like me, wanted to get their brother-in-law in there, nepotism, favoritism, unfairness, meanness, bullying. None of that's illegal at will, unfortunately. And so we look to try to apply the favoritism is actually, oh, they don't like age of these folks. And the one interesting thing, because there are a lot of young people in the cannabis industry, Michigan state law, the discrimination law that applies for Michigan state law, the Elliott-Larsen Civil Rights Act, it actually protects age the other way for youth. So federal law is only for older workers. Michigan state law protects you from being discriminated against due to being younger. So you're kind of reading the tea leaves to see if they're trying to have trying to get certain folks out. And then it becomes a whole separate potential illegality based on one of those protected classes.
That was very in-depth. Yeah, thanks, man. We were just over in Connecticut. This isn't a Michigan thing, but over in Connecticut, there's a large multi-state operator there where 2 women were fired yesterday for exposing plastic shards being, put into pre-rolls there due to malfunctioning equipment. Now, that is not uncommon. There's a lot of things that go on in these facilities that shouldn't be going on. This is generally, and this is something for the workers to really pay attention to, is if it seems off, it probably is. With this high turnover that we have, especially in something that, where there's generally more fine-tuned knowledge involved, like with growing or in a lab, when you have high turnover, there's not even enough time to learn or grasp those things that are very important to grasp. So when you look at a grow like Common Citizen, who just laid off a ton of people, which apparently there was a second wave of people that were just laid off as well. Those employees started noticing a lot of things that were going wrong there. And when those things were being brought up to management and to leaders involved, they're given weird bullshit excuses as to why, they're not doing things up to the minimal code or whatever you want to call it that we have here in the state. And then there's that sort of fear that is struck in afterwards. So with employees that see something going on in their workplace, whether it be mold that they know shouldn't be there shouldn't be mold in the grow. Maybe there's fertilizers or things that are being used.
People licking joints.
People licking joints, exactly. People licking joints and putting them back, stuff like that. What kind of things can an employee come out with outside of going to the CRA and making a complaint that they wouldn't get in trouble for by the law? Is there like a whistleblower thing or?
Yeah, there's a few things that would apply, like for those folks that are exposing health and safety concerns. Those get different levels of protection. I I always tell people, this word whistleblower or retaliation, it gets thrown around there a lot. Hostile work environment gets thrown around there a lot. Even wrongful termination gets on billboards. A lot of those things don't really exist in the at-will world. What we're really looking for to really protect you is whether or not you're bringing something up, first of all, to a government entity. So anytime somebody comes to me with potential discrimination, potential concerted activity that they're engaging in with their coworkers, any of those things, if Michigan law says that you can't be terminated for going to a government entity to report something. And so even if the legal claim seems like I might need more, or it's on the brink of something, I usually still have them get the ball rolling on an EEOC complaint, a Department of Labor complaint, an OSHA complaint for the folks who are finding these shards of whatever it might be, a health department complaint for that matter, of the local municipality or county that you're in, because that protects you under the Michigan Whistleblower Protection Act. But going to human resources does not protect you.
So there needs to be like there needs to be like a paper trail at the government level or something along those lines in order to say like, hey, we tried something like this wasn't, there was some kind of remedy that the employees wanted to.
What stops the employer from firing them anyway?
Well, yeah, I mean, the question is always, can they do that? And I always say, well, it sounds like they just did. But right. The only problem is whether or not you have any remedy, remedy later, back pay, reinstatement, damages, whatever else it might be. I always tell folks, human resources is neither human nor resource. Be very careful with human resources saying, I'm going to go up and complain to management. In the employment labor law world, unless it's about wages or it's you and another coworker or two or more coworkers going together to address workplace conditions to management, those are really the only two times that you're going to get any protection by going internally in an at-will world. And I'm going to get to the two or more workers because I think that's the biggest. We'll save that one because it's the most important. But really what you're looking at is, I think I might be discriminated against. They are bringing in somebody with less experience, of a different age, race, gender, whatever those protected classes are. I usually say, talk to the EEOC just to make a trail that you've gone to a government agency. Now, if you're terminated, it's not just that we can argue that there might be discrimination. It's at least a retaliatory act for you going to a government entity that way. And, it sucks because a lot of us understandably are distrustful of the government, especially in an industry that is not recognized properly, by government officials. But the Michigan Whistleblower Protection Act is so clear that it has to be a government agency, that for you to get whistleblower protection, that you almost have to consider it at some point. OSHA and health and safety have their own, provisions for retaliation. A lot of times you're dealing with this scenario where you're just kind of complaining amongst each other. And one of the most beautiful things that I think this industry, for everybody out there, what they really need to know is that the National Labor Relations Act, and this is an act, that was originally, I guess, made for unionization, for the early days where we were fighting these huge battles to get a union into these large industries. But most employers and most people in general don't know that you don't have to be in a union or fighting for a union or getting towards a union to get protection under that law. It's a two or more workers concerting together to address or improve working conditions. And it's a powerful thing that they've missed. I mean, we've already seen a few National Labor Relations Act charges in the cannabis industry. That's the magic of the Starbucks Workers Union right now. That's the law that they're unionized, that they're doing this under. But even if they didn't want a union in, or they didn't want a large union, they just wanted to be a union at their place of their group of workers together, not even called a union, it's protected activity as long as you are engaging with other coworkers to address these issues. And the beauty of it is social media and the modern era of all types of social media, you name it. It's the law review article I remember reading about it was the social media, the water cooler of the future, that your activity on social media addressing these workplace conditions with coworkers can be protected. It takes you just maybe tagging somebody, maybe having them like it. As long as you're addressing a workplace issue and it's not just an individual gripe and deals with, workers, even sometimes if you're acting by yourself, but you have approval or authority or acting on behalf of your coworkers, you can be covered under this law. We've seen it, I'm sure already a lot of charges are filed. We've done a few. There's a 6-month statute of limitations for folks. I always tell people, if you do it with your coworkers and say, we're concerned about, it doesn't even have to be something like, glass in the product or anything. It can be, I always teach students, it can be that you don't like the coffee or that you don't like, a parking situation, whatever it is. Now, the employer is always free to be like, oh, what did you all do? You have this individual problem, and throw it away. But they can't retaliate against you, discharge you, surveil you, threaten you. They can't do any of that for you acting together for mutual aid and protection of your coworkers. I've even been successful in some cases where it's at the specific grow house or whatever it might be, but it deals with industry-wide things, or deals with things that, as long as you can connect even a large national topic or a large issue, as long as you can connect it to your specific workplace, you can get protection under it. It's a free filing usually. The only real negatives about the law from the plaintiff's bar, from our point of view, are there's limited damages. It's not necessarily meant to be punitive against employers who break it. It's a back pay, reinstatement, posting. Sometimes these things are usually, the remedies to kind of say, if you were fired for your union activity or any of this activity, you're allowed to, force the employer to make you whole again in some way. And cases where workers have worn Black Lives Matter patches and were fired for engaging in that type of activity, those types of things are even protected. And for better or worse, the Biden National Labor Relations Board that enforces the National Relations Act is at least given lip service of improvements and strengthens, and how they're enforcing this. They've added additional protections for immigrant workers. They've added additional consequential damages sometimes that you can argue here and there. And overall, they're really, so many employer attorneys miss this law because they're just taught, hey, they're at will. As long as we don't discriminate against them, we're good. Like, that's the 101 for employer side attorneys in this world. And they completely miss this law all the time.
That's good information, man. I've not that I necessarily would, but I had no clue.
Yeah. And for all of you out there that are activists in this great, doing this great work, everybody here, even engaging in Know Your Rights sessions is protected activity for coworkers. If a list came out of all the folks who are actually learning about their rights, through a great, resource like this, and they're fired for that, that's protected. It's really a great thing. And they should just keep that 6-month statute of limitations in mind and reach out to the Sugar Law Center if they think that they've been fired for it.
Right on. Hey, so we are joined by Darius Rousseau, who's healthcare insurance agent. Helped me out recently, and I know a lot of people are wondering what to do, particularly if they need to continue their care. They might be losing within the month they were laid off or fired, and people get the Cobra option. I don't even know what that stands for anymore. I know it as Cobra. I'm sure it's an acronym that's become a word type thing, over time.
Yeah.
But anyway, it's really expensive. It's kind of prohibitive. It's this obligatory gesture that I don't think it means much to a lot of people anymore. But I got a hold of Darius, and he figured out what I needed and gave me a much better situation. I just thought other people should know about that too. I mean, when you get laid off or fired, your income is now no longer. So that puts you in position to take advantage of some of these things. Hey, Darius, thanks a lot, man. Please, any background on yourself that you'd like to offer, and just to give people the process to figure out what may, to work with somebody like yourself to figure out what their best move is, if they find themselves in that situation.
Hey, thanks for having me on, Jamie. Yes, my name is Darius Russo. I am an insurance broker. I'm a licensed insurance agent. I've been doing this for about 5 years now. I did have the pleasure of being able to help out Jamie in his particular situation. So I'll give you guys a little bit of background, not going into your details, Jamie, but I'll give them a little background into how the process works.
Right.
When you lose your employment, a lot of things can change. A lot of time that can be your health coverage with your employer. When you lose that employer coverage, what happens is you're going to have a few different options available. You're going to get the option that is called Cobra. That is going to be the continuation of your employer's health coverage. Now, while that may sound very good, you're going to stay in the same exact plan that you had before. The difference is going to be that your employer is now no longer going to be paying a portion of it. So you're going to be paying full price for that group coverage. So instead of you paying individual prices, you're going to pay the price for a group by yourself, which in turn is going to be a tad bit expensive for most people. There are going to be other options that are going to be available that are going to work out for you, and they're not going to break the bank or cost an
Breaking up a little bit.
arm and a leg, as I called. There are going to be some income-based out. Can you still hear me?
Yeah, man. It's just weaving in and out just a little bit. I can still kind of hear what you're saying.
Okay. So there are going to be several different options available. There are income-based options as well as age-based options. A lot of people like to go with income-based just because, unfortunately, even though you've lost your employment, that means that your income is going to come down, which in turn is going to offer you a more affordable rate for your health insurance. That is where myself and other insurance agents come in. The benefit to me is that I am an insurance broker, which means that I am not appointed with any one particular company. I'm appointed with every major company, so we can view all of them in a one-stop shop type of place, where we can figure out your situation and figure out what's going to be the best option for you. There are also age-based options that are going to be for a more younger, healthier type of crowd. For someone who may just need something to bridge the gap in between coverages or jobs, there are age-based options that are available. Now, there are some limitations.
And sometimes that might help out with car insurance too. Like sometimes you need to present a letter of coverage to help out with to avoid the car insurance putting the the other charges, the other insurance charges on the car insurance.
Yes. So there are other options. A lot of our age-based options do qualify for what's going to be called a PIP reduction. The PIP is the part of your auto insurance. It's the personal injury protection. And with majority of the companies that I work with, they will work as the primary in any type of automobile accidents. So in getting this affordable health coverage, you also can get kill two birds with one stone by lowering your PIP and getting a more affordable auto insurance rate as well.
I mean,
Now,
I didn't do that just for, this point of the conversation, but in this particular case, but I did explore that option. So when the time comes and I have to do that, there's some different options if I don't have something else worked out by then.
yes,
But that's a lot of money too. So when you're weighing, how much this is going to cost you, based on your circumstances, that's something to keep in mind, because your car insurance could go up without the PIP that he's talking about. So
exactly.
go ahead, man. I'm sorry. I didn't mean to bust in on that. I'm just trying to impose some of my own stuff in there.
No, it's okay, it's okay. And one thing that I do want to stress is that regardless to if whichever route we choose to go, we don't have to suffer on coverage just because of a price point. There are affordable options for everyone at every budget. A lot of people think that, oh my God, I'm not going to be able to afford this, and it deters them away from this. Jamie will tell you, like, we can find some pretty affordable rates for families, without breaking the bank and without you having to suffer on coverage.
Right on. And that is all true. And that's what I wanted you to come on, just make people aware of that. I mean, we talked about it a little bit earlier, but, I didn't know what to do. I was concerned because I've been in situations, I guess, like that before, but I didn't have any, immediate issues. And I didn't, it's kind of wait till I get the next thing or whatever. But in this case, I got some stuff going on. I need to make sure I can kind of continue some, care that's happening. That's when I told them exactly what was going on. And you hooked me up.
And that's one last point that I like to touch on. Regardless to your health status, regardless to your age or financial status, there are options that are available for you. You will not. We do have options available where there are no exclusions on pre-existing conditions. So a lot of times that can be a very big thing. People are worried, hey, I have this going on and I don't want to switch because I have this going on and I don't want to worry and have to, not receive services. Any coverage that I like to find, that's why we go through about a 10-step process at the beginning to make sure everything that you need coverage for, we do provide coverage for it. But as I like to always emphasize to people, just because you may have health issues going on or not have health issues going on, that does not mean that you have to pay an arm and a leg for your health coverage. And when I say pre-existing conditions, I mean it could have been something that happened the day that you were born. We will have coverage for it from day one. Okay?
Right on, man. I really appreciate it. And it was, I didn't know that. I was kind of freaking out a little bit, thinking about, I was going to take a, more of a financial burden if I even could pull it off. And, the news that I got from you, which, might be common, might be well known or something out there to some people, but I had no clue. And I just assume other people must not realize that there's some solution, real solution for their situation out there.
Yeah, definitely.
Do you mind if I give people your phone number, Darius, in case they want to talk to you about this?
Please. And I will also, I don't know if you guys have is there a way post links? But I do have a website that you can go to and you can input your information and you can quote out plans all online. Okay.
Yeah. I think that's better to do that. And Tony, I'll put your stuff back up there too later on when we get back on it. I'm also curious, Tony, your thoughts on the healthcare situation under these circumstances, and if there's any from a legal perspective, is there anything that we're discussing here that needs to be added?
I mean, it's a really good question, and I'm really glad that Darius has provided that as a resource, because the law does not obviously require employers to provide these benefits. The only thing we'd really look at legally is whether or not they're only being provided to folks discriminatorily, right? Like whether or not they're only offered to at the same level, we call them comparators, right? And certain groups of folks are given these benefits and certain groups folks aren't given these benefits, but they're the same, level laterally of their employment. And then we look to see whether it's based on race, age, those types of things. We see it most commonly in a disability discrimination or age discrimination type of setting, where they either, don't want to provide benefits to older workers and they provide them to younger workers or whatever it might be. But otherwise, American law is probably the worst in the developed industrialized nations as far as requiring employer insurance to be provided, requiring medical leave. I mean, a lot of the issues, even with, let's just say, health conditions that might arise. If it's not a workplace health condition, right, which gets its own separate protection under workers' comp, any injury or condition that arises out of or in the work setting, you're supposed to have coverage for. Medical bills paid for, and if you need to miss work, usually I think it's over 2 weeks of work, potential wage replacement of 80% under the workers' compensation statute, right? That doesn't do a lot if it's not a work injury. It doesn't really do anything. And so if it's not a workplace condition or injury, and I should say if it is, even if you don't have health insurance, even if you don't have, your employer doesn't provide it, it's still covered, your medical bills and all of that type of stuff. But if it's not a workplace injury, you really are, that's why we need folks like Darius and plans like that for folks that are affordable. It's why, for better or worse, the Affordable Care Act can provide some folks with relief that wouldn't normally be able to afford it, or at least have it be less expensive that way. For medical leave that's needed, I mean, we are at the bottom of the bottom. You usually have to be at your employer for a year or longer, full time, right? The employer has to have 50 or more full-time workers. You can take all their locations within a 75-mile radius to get to that number. And then, if all those things are met, you potentially could get unpaid leave for any medical condition up to 12 weeks, where they have to actually just hold your job for you under the Family Medical Leave Act. So it's really bad. It's obviously hurts women and expecting mothers even worse. We provide no benefits for that. And it's just not a good situation for medical leave. A lot of times what we see are employers that potentially might offer short-term disability policies, AFLAC or things like that. Those are okay and good. The only tricky thing with those is you usually have to be completely unable to work, pretty much declared to be disabled for the short term to get that relief of those policies. And I should mention, just because it has been the hot topic for a year or two lately, in the interplay between needing to be off of work, whether it's for one of these conditions or just a layoff or firing or quit, we do specialize in unemployment insurance benefits. Now that the pandemic has gone through and unemployment has kind of ran its course from pandemic unemployment, you should know that Michigan, the maximum you can receive per week is $362 a week. So it's not really something you can feed a family on very easily. And it's only maxed at 20 weeks. It was 26. I think it's back to 20 weeks. And you got to show, that you're either unemployed because of a layoff is the most easy way, a lack of work because of a shutdown or whatever it might be. Severance does interplay with this in a weird way for those folks that, Stacey and I have talked about, who are getting maybe a few weeks here and there. That can affect your unemployment in different ways that folks should feel free to call me about. But really what we're looking at is the thing in the community that I'm always hearing is if you quit, you can never get unemployment. That's not necessarily the case. It's a good general rule of thumb to work by, that it's definitely harder to get unemployment when you quit, but it's not something that is a be all end all no matter what. especially if you're dealing with quitting because of health and safety issues, illegal or potential illegal or immoral type of conduct. These hearings can be a little nasty, and they're like little court hearings where you're pretty much putting the company on trial for their whatever were the reasons that forced you to quit. I would say to anybody out there thinking about doing that or who's done that, the law also requires you to put your employer on notice of these problems, giving them a quote unquote chance to address them to meet the standard of whether or not you have good cause attributable to the employer to quit, to receive benefits. And of course, if you're fired and you want to get unemployment, that's the first time in this horrible at-will world that it actually has to be for cause for them to deny you unemployment. The union standard, the just cause standard, if you will, that we look to get in union agreements finally applies, but only if whether or not you can make the measly $362 a week, whether or not you were deliberately disregarding your employer's interests, whether they had cause to fire you, whether you've been warned and you still knew you're doing something you shouldn't have been doing, versus just not being that great at your job, trying your best and doing what you can, being fired, and they always say we don't have to give you a reason, you're at will. All of those reasons, you're still going to get unemployment for those. But that's why I told you the policy or handbook comes into play in these unemployment fights. They point to, hey, you missed a day without calling in. Did you read the handbook 3 years ago when you started? And it says you have to call in or you're going to get points. So you knew, didn't you, when you didn't call in, that you could be fired and would be fired for that. You deliberately went against our policies. That's when these magical toilet papers of handbooks come up and finally come into play. But all of those are very hot topics as well, not just because the pandemic had additional potential benefits involved, but because workers are finally exercising their power that it's not worth, many of these jobs are not worth suffering for or otherwise affecting their health and safety for in order to, make money that they could have arguably made, on unemployment insurance. And that market decision or calculation that bosses have made their whole life are now finally falling to us, and everybody's freaking out saying there's a labor shortage, but we all know that it's just a good job shortage. So any of those types of questions, really the organizing law, the National Labor Relations Act, and the unemployment insurance law is what we really specialize in at Sugar Law. Anything else, I could definitely tell you as much as I know about it. And then if I don't know it, I could connect you with somebody who does.
Right on. Hey, so Darius, is there anything else you want to include about insurance before we get back more on some of the legal stuff and get into some of the union stuff before we wrap it up? I don't know if it's the connection's not working right now. Darius. There you go. You're moving around. So if you can hear me, Darius, anything you want to add about health insurance stuff? Connection issue, I think, but that answers that. But I really appreciate him coming on. That's helped me out a lot, and I just assume that I'm not the only person who doesn't know what the hell's going on. So,
yeah, that's huge. That was really big information. Yeah.
I haven't been faced with the situation for a long time, so it wasn't up to date with what's going on at all. Seemed like maybe some of the rights erode, but it's really glad to hear there's some stuff hanging on. Here's Darius coming back on, maybe. We'll get it. Here we go. Hey, you there?
Yeah, sorry about that. I got kicked out. I'm not sure.
It's all right. Bad connection, I think. But hey, I just wanted to see if you had anything to add before we kind of wrapped up the segment on the healthcare coverage.
One last thing that I did want to add that to kind of touch on. There are options out there for individuals, even those who are still employed. There are options out there for you to add in things like disability insurance or income protection insurance that are available to the individual consumer. that they still have to go through those same regulations of disability, but there are options out there for those who maybe their employer doesn't offer that type of coverage, and they
Some
would
like some add-on riders or add-on
precise.
supplemental insurance.
There's add-on supplemental insurance for you to be able to get disability or income protection just in case there's any type of accidental injury outside of that workman's comp type of umbrella. So I just want to make sure that everyone knows that there are options out there for any type of coverage that you can get through your employer. It is available to you individually. Okay.
Right.
Okay, so you didn't necessarily get laid off, but you want to beef up your coverage and see what your options are with that. That's another good reason to get a hold of the agent. So I appreciate it, man.
Yeah.
You're welcome to hang out and be part of the conversation if you want. But
Yeah, I'll be here.
Okay, right on. If you have something to contribute, feel free.
Definitely.
I'd like to know. I guess I'd like to know a couple things, and that is a general guideline for an employee or prospective employee to kind of gauge if the work conditions are minimally adequate and what that means, maybe. And if somebody on the inside of a organization thinks they could benefit from seeing if the others want to join in a union type scenario, the basic process or the things that they look for to just make that decision and then initiate if they decide to go for it.
Yeah, I mean it's a good question, and sometimes just that word union scares folks away in our American culture of John Wayne, alone on the plane, individualistic idea. So I think it's important, although I know that it's only probably a matter of time for large unions to really, really be putting even more resources than they have in unionizing this industry. It's important that even if, the best organizers I see really don't always connect the goal of unionization as the end. It's mostly, isn't this particular thing bullshit? Like, can you believe this? Do you agree? Like, we should maybe do something about it. Do you want to, be CC'd on an email with me and them? Would you agree to sign a letter about this? Would you just walk in with me when I bring this up? Can I say we? And
Are you kind of suggesting that somebody start with the provision that you described earlier when you have two or more people to address work conditions? You start off by saying we think there's an issue here that should be addressed.
Absolutely.
As part of the process of determining if you want to take it to a union type scenario.
It's about feeling out your coworkers, who's kind of into it, as far as who agrees with you that there's a problem, who agrees with you in raising the bar of a standard, who agrees with you in being willing to at least be included as a we, or an us. It really is that simple to get protection under the National Labor Relations Act. The real hot topic of the National Labor Relations Acts, we just did a training for my law students at my office, is discussing wages and rates of pay. Now that's a real good one, right? But remember, that's also separately protected, right? Like, you can't be terminated for bringing up potential wage violations, right? Already under the Fair Labor Standards Act. Where the National Labor Relations Act adds to that is, let's just say they're paying everybody properly, or they're paying minimum wage and overtime and whatever it is, but you're trying to figure out whether you should be making more. And you're asking your coworkers, what do you make? You're completely allowed to do that and get protection of the National Labor Relations Act. And this National Labor Relations Board attorney who gave us the training on Thursday was like, this is the newest thing. Like, employers tell people you are not allowed to discuss wages and workplace conditions. It's completely illegal. under the National Labor Relations Act. At will, union, non-union, it's just completely illegal, no matter what. And so when they do that, obviously they can be told not to by the board, but even more if they actually take adverse employment action against somebody, demote them, worse schedules, write them up, fire them, any of those types of things, give it an added kind of legal remedy potentially. But I mean, I remember specifically, a booklet that Quicken Loans put out as their isms, they call them, where it's just like their entire, policies in general. And one of them is you should not be discussing, terms and conditions of your employment with current or former workers. And the National Labor Relations Board made them take that entire page out and reprint the whole thing because of that. Like, you're completely allowed to do those things. And I think, we really got to look at if that word union scares folks, or if sometimes every union's an institution, right? Some are good, some are better than others, some are whatever. I do tell people that if you're, even if you're against an institution, the union coming into an industry that they might not know yet, the union is often the difference between whether you can be fired for just cause or just cause, right? I always tell folks that. But that being aside, you can imagine folks in this industry particularly that have probably worked as individuals in many cases, learning cannabis without large institutions because of its new nature of legality, that don't want to involve a national union. The union doesn't need to be involved for these protections to occur, as long as it's not perceived to be an individualized gripe. And the other thing that I really tell folks to watch out, the couple cases I've lost in the past couple of years, even when it is considered protected activity, and they were doing it with other coworkers or on behalf of them and addresses workplace conditions, you don't want to give them an excuse, a non-discriminatory reason to fire you. We had a great case, and the guy went up to his supervisor during the final thing and said, you need to have the fucking balls to follow the law. Like, said something to his supervisor that was viewed by the board as separate grounds for termination, and he lost his protection because of that type of conduct. And so a lot of times, that's why the best organizers are usually good workers. They also are like leaders that are looked to. That's why it's often a slow play getting the union there, because you're there every day building the trust and camaraderie that way. You don't want to give them an excuse, a pretext, or a non-discriminatory reason for firing, because whether it's for discrimination or for your union activity, the law is going to look specifically at what excuse the employer gave and whether it's bullshit, right? No employer is going to come out and say, fuck it, I straight up did fire them for their concerted protected activity, or I fired them because of their age. Never happens. Instead, it's how good their excuse is and whether it can actually be demonstrated, whether it's uniformly applied to everybody, whatever rule they're enforcing. The timing of everything is really looked at. If they just brought up their rights at work with their coworkers and then they're fired, I mean, a good employer attorney on the other side is going to wait, build a case over time, and get rid of you for a reason because you slipped up, way more than they're just going to do a knee-jerk reaction and fire you right after you've done these types of things. And so that's kind of the important thing to remember, and to know that it's just as much as you can to be involving your coworkers and discussing these things with your coworkers, and really trying to connect it to the workplace. The Black Lives Matter patch was interesting because our person was white. He was trying to address certain race issues in the workplace, but it did say, "I can't breathe, justice for George Floyd." It was a very close case. If it's just some national thing and you just want to wear a pin about it, it's not really protected unless you connect it to something going on in the workplace, some type of thing happening. And luckily we were able to do that, there. But a lot of that stuff is just making sure that it's a we, that it's all of us together. And then, of course, the benefit, if it is a union, they will do your board charge with you or for you, or are supposed to. If you're not, Sugar Law Center and very few organizations out there, if any other organization, will be there for you. But usually the board gives you an attorney anyway, right? And they run the gamut. Some are great, some are, regular bureaucrats. But it's beautiful when it works, because I get to tag team the case with a government attorney on behalf of the worker. And we get to try to either, fight for those remedies, although limited. Remember, usually they don't want you back in if they fired you for your union activity. So the bluff or the poker game really becomes, even if you might not want to go back because you've been fired and dealt with it, you don't really want to tell them that right away, right? Because they probably don't want you back even more. And that's the only times where I've seen additional damages be given than just what back pay is owed, is if they want to give a global settlement that they won't be rehiring you and they'll pay more for it, which is common actually. But that's the whole thing. It really is it's a really unknown law from the employer bar. And it's, for folks out there, you might hear labor law and you might hear employment law. Labor law is strictly the concerted protected activity tied to unionization, even without a union, in the private sector. That's labor law. Employment law is everything else. Wage and hour, medical leave, discrimination, everything else. And to even get to either of those protections, it's very important for your folks out there to know, if you are a contractor, if you're 1099 and they view you as an actual self-employed contractor, you lose every protection I've just talked about. You have none of it. And it's very common for employers to misclassify people as contractors, pay them straight pay them under the table, say that you are self-employed because you have some special knowledge and we're just bringing you in here to do this one thing. They get rid of all their employment law and labor law liability by doing that, unless we prove legally that they've misclassified you. It's the difference between, I always say, like, if my boss was like, hey, we hired a painter. He's going to do a lot of stuff for us, and he's going to come in when I tell him to, and we're going to tell him what to do every day. And he's also going to fix this, and I'm going to tell him every little detail, and he's going to have a sugar law, email and all that, versus we hired a painter. He's great. He can hold himself out of the public and do other jobs. He can do the job. He has control over his own tools and everything. He comes in when he wants and pretty much does it, other than when we're open, and that's great. Those little nuances give completely different legal protections under the law. And it's a big legal industry for employer side people to figure out how to make employees contractors, because they know that liability goes down the tubes. I mean, they get so much less risk when they're able to do that. So if any of your folks out there are contractors, even folks that are salary or sales people, commission people, they're treated completely different legally under the law than regular W-2 normal deducted employees. And it's the first question on any employment law or labor law intake. So the first thing when I meet new students, new person's calling to see if they have a case. First question, are you an employee or a contractor? How are you paid? Regular W-2 or not? If it's contractor, you're in an entirely different world where it's just like a regular contract. What were the terms of your agreement type of thing for anything to happen, versus an employee. All the laws I've discussed, you have to be an employee for those to apply.
So would that be like temp workers then, which we see a lot of in cannabis, a lot?
So temp workers can usually be both, right? Temp is a classification, like a rose, but a different name. Like you can see a temp worker that, listen, you're going to be a W-2 employee for a temporary amount of time, seasonal type of deal. you're still paid and control. You're still paid W-2 and you're still controlled by the employer. But a lot of temp workers are, hey, you're hired, you're brought in as a contractor for the limited purpose of this one thing, and we're not here to, it's a 7-part test under the law. So the control is the universal factor, but it's no one factor is a silver bullet. And so the departments of labor or the lawyers involved usually will have to say, hey, even if you were a contractor and you were 1099 or paid cash for this specific temporary job, maybe you were misclassified. Maybe they directed your job every day. Maybe they told you what you had to do and how you're supposed to do it every single day. And if anybody wants to search it, the test is called the economics reality test. And there's a little nuances different in state and federal law, but they're mostly the same. And all the things about whether you bring your own tools, whether you hold yourself out to the public, whether your employer can direct your schedule and control how you do the work and when you do the work. Those are the main bullets.
I think I was misclassified years and years ago. As I said, I'm old now.
Very common.
I was I guess 1099 laborer for a moving company, but they scheduled me on a regular schedule. I didn't really do that for anybody else. I didn't advertise it. I just moved for whoever wants to hire me. None of that kind of stuff. So I think that was a case for that.
And remember, not only do you lose the legal protections, all those wages you make, they're going to want the taxes on those for you to pay at the end of it all. Sometimes I think around 15% minimum. So, the IRS can also come back at you for that as you lose your Social Security protections. I mean, it's just a totally different world. And it's, unemployment got a lot of media because for the first time in American history during the pandemic, it was extended to 1099 self-employed gig. They're called gig workers now, economy workers or whatever. And, this gig economy where it's like, until we're selling apples off the side of the freeway, like the Great Depression, and picking up 8 different 3, 4, 5 side hustles, they call them. They really try to, sex up all these actual complete and utter horrible things for workers. And when I always bring up the George Bush on the campaign trail, when a low wage worker goes to him and is like, I'm just freaked out. I have to work 3 different jobs because none of them provide me health care. None of them give me full-time hours. None of them give me a path to, promotions or whatever. They're service and retail industry jobs. I got to pick up shift after shift, and I'm working 3 of them to make ends meet. And he just goes, wow, that's so amazing. It's a uniquely American thing. Good for you. You got 3 jobs.
Oh, I remember that. Yeah.
3 jobs.
Uniquely
This
American.
is the whole point, that's the
Right.
future of our gig side hustle economy that, they try to make us all Uber drivers or whatever, but it really is just peddling apples off the side of the freeway.
Yeah, I mean, there's something to be said for those who make the initial investments and have the vision and the strategy and put all that stuff on the line to make something happen. But if they're going to bring in the lives of all these people to help come support this vision, I mean, that it has to expand to like having a reasonable way of dealing with them throughout that process. I mean, in order to be able to operate like that.
And a lot of times, I do feel bad. Many of our clients come to me and tell me that they wanted to be paid that way, that they actually tried to work it out, that they were cash or otherwise, off the books or under the table contractors before, of course, something bad would have happened and now they don't have any rights. But, for various reasons tied to court judgments, to child support, I mean, you name it. But a lot of our low wage workers that we serve at Sugar Law Center, they're like, well, I would prefer that it's paid that way. And then we have a whole other separate type of conversation, I guess.
All right, so people want to fly under the radar, don't want the taxes taken out,
Yeah.
that type of stuff.
So I definitely want to get into the WARN Act. I know that we had talked about it a bit, Tony, and maybe brought it up with you too, Jamie, but that's definitely, I think, something that should really be on everybody's radar right now as we see some of these larger places closing down, groups of dispensaries closing down, grows closing down, and what have you. So,
Well,
Tony, you want to get into that?
I was really excited to get that, issue spotted because Sugar Law Center started the late 80s, early 90s at the same time as the WARN Act, WARN, Worker Adjustment Retraining Notification Act. It's a federal law that came to be almost with the Sugar Law Center. And when I started, 15, 16 years ago, it was a big deal because we were one of the only law centers that dealt with it because of its limited remedies, and we were being a nonprofit, but more so because it was during the Great Recession, and it was during this closing of, literally almost everything, largest depression recession since the Great Depression. And so those intakes were the first thing that I did for years and years and years. The tricky part about the WARN Act and why I was excited to see that potentially come through is the modern economy doesn't serve what the WARN Act was made to protect anymore, because it was made for the closing of the Rust Belt's large-scale factories. You have to have pretty high numerical thresholds of people affected for it even to be in play. And as we saw factories close and us move to a economy more with smaller offices or at-home offices or smaller places, the WARN Act literally kind of went in the back burner. I see maybe one a month, if that, in the past couple of years. Even with COVID, we didn't see a lot of them, because the WARN Act is a federal law and it was a product of compromise. It's amazing in some ways that they even passed anything, but it required a minimum of 50 people at a site. And site, quote unquote, was strictly interpreted as a site, right? Like the cases I remember were different college campuses, different college buildings on the same campus were considered different sites. Different mines connected underground, but had different addresses above ground, were different sites. It was really strictly interpreted. You have to have 50 affected. You have to have at least 100 employed by the employer. Now you can take all employees in the country to get to that one, but the 50 affected at a site was just so bad. So many modern places don't have 50 full-time workers there at a specific location, right? And then even worse, if you get to the 50 and it's not a full-out closing of the site, which would probably give you protection, you have to have a third of the site or more laid off. So it's an easy law for any, corporate attorney asshole to game, because he's going to be very able to say, lay off 32.5%, wait a certain time, and it's this numerical threshold type of thing. But when employers miss it, because just like the National Labor Relations Act, it's so unknown, sometimes they miss it. It does require the employer, before they lay you off or close your site, to give you 60 days notice or 60 days pay in lieu of notice. And there's other provisions to the law. They got to notify the local mayor or the leader of that city. They have to notify the state's rapid response Department of Labor type of entity. It was made because these factories were closing without notice and literally destroying towns and communities throughout mostly the Midwest, but you name it. I watched a weird thing about the football team, that moved from the Baltimore Colts when they moved to Indianapolis, and they packed up in the middle of the night and went to Indianapolis. And that was technically a WARN Act violation or case, Where we see it lose protection is not only did an attorney game it and get under the threshold, or it's too small of a place, but oftentimes a severance is given and a waiver. And the court cases say that any money that they pay that was not already required to be paid pursuant to policy or contract, you're allowed to offset any of the 60 days from, right? So I always tell folks, if they got about 4 weeks or a month, I'm like, man, that's the line that's hard for me to advise on, because it's like, you can roll the dice, not take your 4 weeks. You might lose, or might have an attorney take fees out at some point if you get the full 60 days, right? Or you take the 4 weeks and move on, move on with it. They're supposed to give a notice too. They have to give you, the union or the workers, individual notice of why they're doing it. Employers have these other things they can use called an unforeseeable business circumstance, where some unforeseen downturn in some market force, was the cause of it. Those employers use those a lot, but they're a little hard for them to use because the employer has to prove that it wasn't at all foreseeable. There's a lot of that type of stuff that we see the cases there's no teeth to it. It doesn't take an economics major to know that if the law that is passed, even if they get busted, all they have to do is pay what they were supposed to do to begin with. Well, they usually roll the dice, and if they get caught, then they just pay what they had to pay, right? And it sucks that a lot of labor and employment laws are just that, remedial. There's no punitive things to kind of incentivize the employer's side to properly follow the law. But in the cannabis industry, more than I'd say many other industries, you're really seeing there's larger workforces. You are allowed the site being strictly interpreted. The exception is if there's a constant work sharing or flow from site to site. You can sometimes group those folks together. We've seen employers mess up and close a division, but not the whole site, but an entire division of a site. And then you can argue that it's actually a closing, not a mass layoff. We've seen them mess up and go under the 1/3 threshold properly, but not wait long enough, because you're allowed to take all the layoffs together in an aggregate that happen in a 90-day period. And you're allowed to then add them in. So we've seen employers say, hey, lay off a few here and a few there, and we'll get through it. But if it's within 90 days and you get to that third, they need to pay that 60 days, right? And so, we see some of that. And they're usually class cases. Any waiver can relinquish a lot of that, but mostly we're always looking for whether or not the employer even knew about the law to begin with, because sometimes, the cases that I've done, the employer will then say, well, we had the price of, like, for example, the price of marijuana just plummeted, and it was no longer sustainable for us to maintain our current staffing and labor obligations or whatever it might be, or we couldn't afford it. Well, then the fight becomes whether that was really foreseeable or whether it wasn't foreseeable, and a lot of times employers struggle with proving that if they're such experts in cannabis and the market, that why they didn't know that this was, potentially happening. And of course, we always look at a separate analysis of whether or not everybody that was chosen to be laid off versus who was kept, if it was along the discrimination lines I mentioned earlier, based on one of those protected classes. That's a separate analysis in the Warren Act. But you'll see, if you see any sites whether they share work or not, 50 or more, that you see these layoffs occur. And then even if they're under the 1/3 for now, to keep a close eye on them to see if they're going to continue to lay off folks that way, it might be worth looking into. There's some major exceptions. Railroads and certain federal types of contracts are not supposed to be included. There's a very strange thing too. You're not considered to be an employee for threshold purposes if you haven't been there for 6 months yet. Even if you were full-time for those 5.5 months, you're not allowed to be factored in for threshold purposes. Another ridiculous, nonsensical, likely product of compromise, that occurred as we, passed this law, a long time ago. But I think it's something that most employer side lawyers, whether they're on my side or the other side, they don't know about. In employment law and law school, it's a chapter at most. It's a really unknown law, and folks should be aware of it, because what I would do is you usually try to then, if I do represent any of them, to bargain for at least the 60 days, and if they are going to do a waiver and it's only a 2-week severance, right? It's probably might not be worth it if they got a chance to fight it. But otherwise, it's really something that I'm really glad that it came to our table, because we have with our board, it's always like, oh, what's up with the WARN Act? It's the only consistent thing through sugar law's history. It's unemployment during the pandemic. Oh, it's discrimination. No, WARN Act has been the one thing that we are at least hold ourselves out as national experts on, and we really haven't seen a lot of those cases. So I'm glad it's potentially applicable here.
So what can employees do, if they watch this episode, they hear about the WARN Act? Would they contact Sugar Law? Do they all have to, can they all be represented, or how does that, or is it just an individual basis?
They're almost always class cases. So yeah, they should contact us. We would usually, there's reps that are chosen for class reps, anywhere between, 2 to 5 reps of the class that have commonality with everybody that's been laid off. I know it's very difficult for employees to know this, but just a vague and general idea of how many people were there, how many people were affected is big. The employer is supposed to report these to the state of Michigan's Rapid Response Unit. Sometimes those are published through the state of Michigan or otherwise FOIA-able of how many were affected or laid off there. Because for me to send it to the next level of potential representation or litigation, I got to at least have a ballpark, right, of how many they think were there. If it's close, I think my boss John will usually push it, but a lot of folks don't know how many are there, or don't know how many have been there for 6 months, or don't know, what it is. Don't know whether or not how many people have signed it. Now, if you're going to be a rep, you can't have signed a waiver and release already. The waiver and release doesn't change the threshold, doesn't take you out of that, but it does change whether that attorney can evaluate whether there's a class that's viable for representation, right? If all but 4 sign it and those 4 are involved, Sugar Law might be able to take it because our model is not a regular plaintiff side model. But going out there and finding a regular employment attorney who needs a third of that class case is going to be very, very, very difficult,
Oh, hey, Jamie, you're muted.
I'm sorry. I was pointing out, first of all, that there's a question that's taking up the whole lower part of the screen. And Tony's totally washed out for a second here. But it says, how would Tony advise job applicants to navigate topic of drug testing as a cannabis patient in Michigan? I've been unemployed since moving to Michigan to become a patient 10 years ago. So navigate topic of drug testing. Okay, so just if you are a patient and they test for drugs, the company, you're a registered medical patient and the company tests for drugs.
It's a really good question, and something that, although our state's made all these strides towards recreational and legal cannabis, why I think it's always going to struggle for the economy to catch up with or not our economy, just general job provisions, right? Because not only is it still got this other classification federally, but it really is, and it would probably be a good topic for Darius or something. It really is the insurance industry that screws this whole thing up, right? Because literally we have probably most major insurers for employers not want to take the risk of knowing that they have to allow for a positive test, right? Because it's legal.
Right.
And then to say, hey, you have to look the other way. Well, then, especially for Department of Transportation or any type of large scale machinery or whatever, now these lawyers and these insurance people are probably like freaking out because they're like, you still have to say that you can't be high, because we're going to be in trouble if we allow it and there's any type of, things. We're going to be on the hook to say whatever. Insurance rates are going to get jacked up if we're looked at as one of these places that properly does it. So the smart model would obviously be a case by case. What is this job? What are they going to be doing? Smart model number one is looking at what the job is even being applied for that they want a drug test regarding. Smart policy number two would be giving us a test that's not whether it's ever been in your system in the past week, but how many active metabolites are going on in that moment of test, like when you're there. There's a big difference between testing positive because you were high the night before.
Yeah,
and
even then it's deceiving because people are sometimes, not are perfectly able to provide any function, whether or not those things are active. So I think a part what you said is like the employers are going to have to decide for themselves at some point that they don't care about that. So it's not an issue.
Yeah, they're going to have to decide for themselves. Right. And they're really going to have to be very careful, again, to make it a uniform policy. It's almost like it was described to me. They were rewriting the South African Constitution, and the guy who was writing it came and taught us all this stuff and goes, America, you all have equality of the grave. You call it equality, but if they're shitty, but shitty to everybody, they're not really illegal.
Right. Yeah, we're equally being shitty to everybody. Right.
Yeah. It only becomes illegal if, for example, the person asking the question is targeted to be tested because of age, race, gender, disability, any of those protected classes. Then you got a separate case. But if they stay on it and uniformly enforce a shitty policy to test everybody, no matter what, and do whatever, we're in more trouble, right? Because legally it's that way. And the South African guy was trying to be like, no, it's not really equal. It's not like a good law because they can be, as long as they're horrible to everybody, they're meeting employment law standards type of deal. But really, we see it a lot where
that's not the intent, though. That's somebody, interpreting it conveniently. Obviously, if you're trying to be broad and liberal, with intent, you wouldn't assume that was,
exactly. And, we see it where for refusing a drug test, that's why I still advise people, and this usually happens after employment has already been given, right? Some random or some zero thing, to take it, at least for unemployment purposes. If you just refuse, you automatically, the law doesn't allow you to get unemployment.
Yeah, you could challenge something potentially, right?
Yeah, if you take it and you test positive and you're fired, well, now they're not going to be able to show that you were high or had active metabolites in there. They're using a shitty test, right? They're not going to be able to say that you broke a zero tolerance policy because they can't really have a zero tolerance policy because they're not allowed to go to the things you do outside of work for unemployment purposes. The misconduct has to be connected to work. And so I've seen all these tests where it comes back and you just get these human resource people on them. Like, you didn't have a test that could tell whether or not they were under the influence during work that day, do you? No. In fact, you all know that this is just any positive test, regardless of whether it's legal, regardless of whether they're a medical patient, still applies, But the real shitty case out there, and why we can't even use medical marijuana as a disability discrimination, which we've tried to push 5 years ago, is Casillas.
I was just about ready to bring up Joseph Casillas. First of all, I know him.
Yeah.
I know Daniel Koropkin, the ACLU lawyer, and I know Dan Groh, the other lawyer who took his case. And if you want to explain it, go ahead. But I was going to bring that up.
Yeah, we really tried hard. That would have been a groundbreaking case. And all the good things that I told you, that's just unemployment, remember. That's just your 362 in between jobs. It's not whether or not they could do it to begin with. And he was a model Walmart employee. He was a floor buffer and cleaner, and it was just this great no write-ups or anything, and was an early a medical marijuana patient in Walmart of all
and he
companies.
has cancer. It's not just like he was just a patient. I mean, it's like he had cancer, and he was using outside of work, as you were just describing.
And in Walmart, so it added fuel to the fire for most of us labor rights folks. Fired him, and the Supreme Court, said pretty much that although Michigan has legalized it for medical purposes, it doesn't change the nature of at-will employment, and it still is recognized as this issue federally, that the employers are still allowed to father knows best.
So it didn't stay in state court, just to clarify a little bit. It quickly, because the headquarters of Walmart is located in, I think, was it Louisiana or something, or
Arkansas.
Okay. And the manager is just a stooge of the policy, because they originally tried to sue the manager for firing him, and because the MMMA says you can't lose your job or privileges for you're supposed to have immunity. Actually, it's just been disregarded, for years. And so they threw it into federal court, and they have no regard or respect for, the Michigan Medical Marijuana Act there is having those types of protections. And so ultimately, my understanding is, unless it's a state, a publicly operated Michigan state-based company, or a state department of some kind, that you can not recognize the MMMA and the protections it's supposed to have.
Yeah, okay. And then I don't know the name of this one, but there was a corollary case that came out where, when Colorado was the first one to, I think they were first to do it recreationally, then they tried to bring a Disability Discrimination Act case to say, as a cancer patient, as somebody with a disability, this is an accommodation. I need this to be accommodated. I have a disability that affects major life functions, and this is a small accommodation to allow for a potentially positive drug test for things that happen outside of work with a legal substance. You need to accommodate this, employers. And it was brought out of the federal circuit of Colorado, and that lost as well. So it's one thing where the law, and I tell this, and why the great work that's being done to organize and to do it through the National Labor Relations Act is so important, because the law is usually the last to catch up to anything just and good in society. It's the people and the movement and the hearts and minds of folks and the culture and those things that wag the tail of the law. The law, although, that's where everybody looks for guidance and power and whatever, it's old white has-beens. It's old white dude has-beens that are trying to preserve a status quo to keep our economy predictable. And that's why the movement that happens, the law is usually the last to catch up. And a lot of the great work that's being done to kind of make it where there's a legal arm, of course, but the other parts of the body are fully functioning and moving these things forward and changing minds, are really why Sugar Law Center is unique, and why Maurice Sugar, who we're named after, who was a lawyer and a labor activist in the 30s when there were no unions yet, trying to really get the people out there to demonstrate and to do these types of things and to kind of show what the law should say, as opposed to, oh, that's illegal, we shouldn't do it, or whatever else. Most lawyers are trained. I tell young law students and half the corporate attorneys I go against, if you were just here in the legal world to make or to enforce existing law, you should have been a cop, right? Like that's what it is. We have to push these things forward. We have to tell them what it should say and everything. And I really like that all this great work has happened, because those test cases are going to be what later on we act like that's just normal and fair and how it should be. They don't know that it was, the heart, blood, and struggle that came out of it from the organizers and activists like you all.
Right on.
And that's, when I know it's getting close to 9 here, but when it comes to workers unionizing, like it isn't just about the act of unionizing. It is creating a standard that we don't see in cannabis. We're not seeing a standard. There is no self-correcting. They're not doing it on their own. The issues of, health and safety in the workplace, employees aren't just automatically jumping up and saying it's time to unionize. You're trying to remedy those situations, and they're not being taken seriously. So by unionizing and being able, you are setting the standard that your employer and the industry refuses to set for itself. And that's huge. That's huge. And we desperately need that right now, because this is, everything is kind of crumbling. And without some kind of, precedent for, standard operating procedure, I mean, this industry is going to go bye-bye here pretty quickly. And a lot of these small townships and municipalities who got all these promises are going to be left with a bunch of empty buildings again, and that isn't what this was supposed to be about.
Exactly. Yeah. And, the one thing I will say too, because you're absolutely right that we can't rely on the father knows best model of, oh, give us fairness or whatever. Power seeds nothing without demand most of the time. But the nature of the American legal system being so top down or whatever, remember that your local ordinances, your state laws, those are always kind of a little more ripe to move and change than ever trying to think that we're going to get federal disability law to recognize this as an accommodation. Even the Warren Act's limitations, right? States like California, Illinois, New Jersey, and New York, I think, they've passed stricter plant closing mass layoff laws. California's law got rid of the 1/3 requirement, lowered the threshold to 25. A lot of these, laboratories of democracy or whatever we learned in school, where you can actually do that work on a local level easier in many ways, and you saw it, of course, with the decriminalization of things in Ann Arbor and Detroit before it was passed, recreationally here. Those are, for lack of a better term, God's work as we start small and then build the movement out that way. A lot of times I think that we just hope that, the president or somebody is going to do any of that, but it really is the boots on the ground grassroots work that you all do that gets things done, even legally.
Got another guest on the show, eh?
Yeah, doesn't sound too intimidating, but she's okay. Warning me that somebody's coming in. She's an alarm. That's the best value out of that. But she's like 6 pounds. But anyway, so now if I'm not mistaken, Stacy, that Michigan has had a place or two where there's been some organization. Is that right?
Yeah. So currently, like right now, the Loom dispensary in Monroe, Michigan, they filed for union recognition on, I want to say the 26th. It was about 2 weeks after the 4 closings. Now, there are a few places in Michigan that have successfully unionized, and they're small mom and pops. There's one location. They might have 10 employees, maybe 8. But they generally, do that to get the employees affordable health care and realize that they don't really have all the answers to everything that's going on in the industry, and the union can really help with that, help getting.
So this is a way for the operators to benefit from working in a good way with their small workforce.
Yeah,
that's pretty cool. Okay, that's neat.
Yeah, absolutely, for sure. There's, I don't know, it isn't really big in this area and stuff, but some bars and stuff have joined the UFCW solely so they could get affordable health care for their workers, employees. So there's definitely a lot of benefits to it, definitely. But I keep remembering to look up the name of the one place. It's in Muskegon, and I forget what it's called, but they unionized earlier this year. That is one. I'll look it up. I'll post it on my Instagram. I'm sorry, I should have had that for you guys.
That's okay.
But
But so you know of some small places where it just makes it conditions better, even for the operators, even for the owners,
right
and the
now,
loom and kind of reaction, or at least it appears the timing was like such that it was after the four places were just unexpectedly closed down, and then now there's a place in Muskegon. Also, there's some activity in Michigan, at least, without even having to know a lot of the detail at the moment.
very much so. And there was definitely union activity at Common Citizen that comes from the workers there. There was several workers in multiple different areas of the building that didn't talk to each other because they were kept from each other. One might have worked in room 1 through 4, and the other ones worked in trim or whatever. But there were several different small groups of people that were in contact with the union. So there were attempts to try to rectify the situations that were going on and the harms that were going on at Common Citizen. And just kind of makes you wonder that. And I don't know, just off the top of my head, it just kind of makes me feel like there might have been more sniffing around with Lumen employees as well, as far as unionization goes.
Right.
Look at Starbucks and what they're doing, right, with their employees that are trying to unionize. They'll close the store. And they'll make up some dumb excuse like, there's rampant drug use in this area of Philadelphia, so we need to protect our employees by closing down the store, which doesn't make any sense. It doesn't. Here we are with that. So again, employees and cannabis workers out there are ways to fix what's going on. You don't have to jump from spot to spot to spot to spot. You feel like a foster kid at a certain point, right? I talked to so many workers that worked at 6 different dispensaries in a year, not by choice, but they got let go from 2. The other 2 they couldn't make work with the wage that was there. And all of a sudden you're at the 5th or 6th place, and you're like, what the hell am I doing? I want to be. You feel like a foster kid that isn't getting adopted. So. Yeah. Unionizing is a way to kind of solidify yourself and your coworkers in an industry that can have a future. We want it to, right?
And as Tony said, it has to have the right balance of things. Provide the right services and in a good way in order for it all to kind of come together and make sense. So there's a place in Manistee called Authentic 231. Did you mean
that makes
Manistee?
Sense?
Okay.
Yes, that makes sense. Yeah, that was earlier this year, I believe. That was with the UFCW 971, I believe they organized with, or 951.
So this article's from March of 2022, so that would make sense. So, and then they're just seeing a headline here, a place in Battle Creek that did it too.
Perfect. Yeah. So, and I think that they were smaller places too. So there hasn't been, as far as I'm aware, any place in Michigan that has multiple locations that have unionized. They've just been, sole single stores. I'm not familiar with any grows that have unionized either, but a grow would be a very beneficial place to have a union at because that's where we're seeing a lot of the issues that bleed into all the other sectors, right? That's where we're seeing mold, and that's, where a lot of things are done that end up affecting the other sectors. So if you work at a grow and there's a lot of, stuff that you're noticing probably shouldn't be taking place. Definitely consider talking to a union organizer about, the conditions at your workplace and what you can do about it.
So I think we kind of touched on it, but is there just a place somebody's watching or going to watch this and they say, hey, I think that, we should pursue this process? Is there a place to go that gives people the initial steps to take to start exploring? Besides having to hire the law firm right off the bat, not that wouldn't want to see that when people need it, of course. And I appreciate Sugar Law having a unique service for people. Definitely during this conversation that shows up, a lot, but the initial steps for somebody to explore, what is there a site or something that you like, Stacy, like using for reference material?
So there's several different sources. There was actually just a great video that a group called More Perfect Union put out either yesterday or today. It's about 8 minutes long, and it explains exactly what you need to do in order to get to the point of unionization. And the first thing that you have to do is start talking to your other coworkers. That is number one. It can't
It
just
sounds like
be
advice
you.
that Tony was giving. More than one person needs to
Exactly.
experience this, issue. Right.
Right. So if you go to my Instagram, which I don't know if you want to put that up here, I have a lot of different links in my link tree that can take you to like the Cannabis Workers Coalition. Sorry. There's More Perfect Union, which is great. There are a couple other sites as well.
Stace of Base. I'm sorry to interrupt you, but Stace of Base 85, exactly right there.
Yep.
Okay, so it's right
Yes,
there, but
sir.
I'll put it up here too, just to.
Yep, you got it. So there's several different resources that were definitely not around, just a few years ago. Obviously, I think Sugar Law's website has a decent amount of resources as well. There's definitely some good stuff out there. So I would start with, though, on it, like the best. I think that Perfect Union did a really good job at this little video. But you follow More Perfect Union on Instagram or on TikTok, and they not only cover a lot of different unionization efforts that are going on around the country with like Amazon and Starbucks, but they provide, resources and good little tidbits and videos of what you can do when it comes to unionizing at your workplace.
Uh-huh.
Hi, I'm Sola. And I'm Ham.
So
and
it's this.
Today we're going to give you a recipe for how to form a union.
Yes, that's it. Yeah, they're baking a cake.
We're gonna bake a cake. Don't worry.
Yes.
It'll make sense.
So that's enticing right there. You have to see what happens next.
Honestly,
So,
it's a great way of
Perfect
explaining
Union.
things. Easily palatable.
Yep. So Perfect Union. More workplaces have filed to form a union, something or other. So you can find it. I found it, and that looks cool. Maybe you'll emphasize it on your page, and just try to get it out a little bit more so people have some kind of a process to be aware of when they're evaluating it. And again, maybe they've got conditions where they are that don't necessarily warrant it, and maybe their choices right now for people to work with aren't the best fit for the stuff they need. I mean, there's all these considerations, but to have some start of going through the process and figuring out what's best for your situation is, I think, important. And is there consultations that you might give, Tony, formal, informal, just to help put people on the right track when they're trying to investigate this stuff?
Yeah, absolutely. In fact, by the time they would want to really reach out to me, they probably filed a charge for being retaliated against for their union activity, right? All the stuff that happens before that, the law being a reactive thing of negativity versus, the great organizers out there. In our building at Sugar Law, the Cass Commons, there's even a group, Center for Community-Based Enterprises, or C2BE. It's kind of like a union thing, but it's towards the goal of employee-owned or controlled businesses. So it's even another model for cooperatives when they can exist. But normally all I do in those early stages is connect them with somebody like Stacy or Graham Kovich, another great organizer that does a lot of stuff in the service industry. That is just even sometimes resources put out by the IWW. It's an old union, but their resources are just really, really good because they were always focusing on a broad type of tent of how to, educate and inform and activate these people. So yeah, by the time it gets to me, it's usually somebody's been treated like shit for their union activity. So all the stuff before that, it's even better when folks can just get together. And I know even with the work I do with Graham and the IWW, they usually try to use the lawyers only when necessary, because so much of it should be empowerment of the workers at that facility, as opposed to waiting for some, top down or some person to come in and kind of fix it. Normally, everything from when to go to the media to when to, how to do things. Great organizers control long before I'm ever needed.
Right on. So yeah, so people to explore this, and they need to do something or respond to something, and you need real legal representation sometimes in these processes, unfortunately, and that's a good thing that there's these specific services with people who understand these things are available. It's cool that you were able to come on here and let us know about that, Tony, and answer this very specific questions that we and many others have and are currently struggling with. I think there's lots of people who are facing this for the first time or for the first time in a long time, in some direction.
It's a great resource, and like I said at the beginning, it's just perfectly ripe right now, and we're just glad to be a part of it. And remember, we're just the effect of the cause that all of you are doing. So I just kudos to all of you as well.
Right on. So we're going all the way to 9. I didn't really put a time limit on it, but our shows are normally 2 hours, so this works out pretty well. It's like 5 to 9. I did put the link to the Instagram video in the comments. It's easier to hit the link from the comments there than just copying the weird, several letters that don't make any sense on just posting it up here. But hopefully some people can start checking that out or even circulate it, or we'll get it out in other ways too. As we said, Stasa Base, putting lists of resources out from time to time. You can find some, a lot of the stuff that we're talking about there and other places.
And if anybody is, it can be kind of intimidating depending on, where your knowledge base lies when it comes to unions, because there's a lot of negative stigma there that's, unwarranted. But, if you're leery about reaching out to a union organizer, please reach out to me. I don't work for any union. I'm independently just trying to make an industry and help the coworkers that, are really
people know what their options are. Yeah,
for themselves. Yeah, exactly.
Very important.
Exactly. What the options are without having to go too deep into, a union effort like that. So yeah, please hit me up.
That's why I'm explaining that, it's just not just the point of unionization. There's, there are things that have to be considered along with that process that make sense for everybody involved in order, for it to work out. But the idea of helping to shape, what fair standard work conditions are in this emerging industry is definitely a good one, and the union effort, that process to determine that, is a good way of getting of helping with that. And I like the story of the smaller businesses just choosing to do it. Just that makes a lot of sense too. So I guess, Tony, with just a couple minutes left, is there anything you want to make sure that you add to the conversation? Obviously sugarlaw.com. I'm sorry, .org. I had it up there for so long. Should have known that.
Yeah, nothing else. I think we covered it all, but just know that it's an ongoing conversation, and we're here for all of you and all the listeners out there as this industry, moves forward. I'm really glad to be a part of it.
No, cool. And I'm glad that there's somebody, with your expertise and, understanding that this is a good place to be, for this kind of stuff. I mean, I don't mean that as a positive situation, but I mean, for you to be able to, be aware of this and focus, those services on these people who need it, is a good thing to have in the midst of these issues that are popping up. Hopefully we can turn the tide or correct some of these approaches and not just let people get run roughshod over, which is, one of the reasons I wanted to do a show like this, is because I keep on hearing about it. And I don't like it. I've experienced it myself to a degree. I mean, I feel a lot more fortunate than some of the people I've heard about. But I don't like it. And there should be some consideration for those who, for that mutual relationship that happens, to get an operation up and running. I do respect the investors and, and the risk that get taken. But, they're still a part of the equation that shouldn't get forgotten because of that. And there's a balance there. And I think this discussion talked about that. We try not to say we just need to do this for the sake of it. I mean, there's good reasons for it, And I just appreciate all the good information that we got out to people who might want to explore it. Stacy, do you want to finish up with anything to add, or just to wrap it up?
Hey, again, thanks for doing this, guys. This is important resources for a lot of people out there who are just kind of like, I don't really know what to do. So, know that there are resources out there, and there's a lot more people in the same boat. And it's not a boat that you necessarily want to be in, but it's a boat that's you can head towards change. So, again, thanks for doing this, Jamie. Thanks for doing this, Tony. There's going to be a lot more issues to come, but the more you know, knowledge is power.
We will revisit this maybe on the regular show, or maybe with another special edition. But ongoing conversation and requires some updates from time to time, and maybe some new information for people. So thank you, guys.
Thank you.
Special Jazz Cabbage special edition.
Later.
See you later.